moving on this afternoon, we started this morning by both Harry and I in our opening remarks referring to the obvious economic growth that's happening in Africa at the moment. With economic growth comes a growth in legal disputes. No doubt the reason why we were given the moniker sharks by Harry this morning. But growth in legal disputes is something that we are experiencing at Brick Court. And my three colleagues sitting two to my left and one to my right are extremely well placed to be addressing you in this session in which we are considering the approach of English courts to disputes emanating from Africa. To my far left is Charles Hollander, who will be speaking first, followed by Tom Adam and then Edward Harrison. And without any further ado, I shall hand over to Charles.
Well, good afternoon. Challenges of acting for African clients are sometimes a bit different. So, you act for a government organisation in litigation before the English courts. What happens when a dispute arises as to who is the government? Well, I can tell you this, you won't find the answer in the White Book. I need one of these things. Sorry. No, other way. Yes. That's been the issue in recent proceedings involving the Libyan Investment Authority. The Libyan Investment Authority is the sovereign wealth fund of the Republic of Libya. And it has two sets of proceedings in play at the moment in the English High Court. One against Goldman Sachs and one against Société Générale. And one coming on for trial in 2016 and one in 2017. And this is serious litigation. Each of the claims are over $1 billion. The Libyan Investment Authority acts through its board of directors, and appointments are controlled by the Libyan government. Now, as you may be aware, there's been civil war in Libya, and that raises the question as to exactly who is the Libyan government. So, on 25th of June 2014, with the support of the United Nations, national elections were held in Libya. And the House of Representatives then invited Mr. Al-Thini to form a government. However, a rival faction, including insurgent militias, styles itself Libya Dawn and includes members of the former General National Congress. And the militias have driven the Al-Thini government to Tobruk and have seized control of Tripoli and styled themselves the National Salvation Government. So you can see, therefore, that in these proceedings in the High Court, an issue arises as to who is the Libyan government and, therefore, who can represent the Libyan Investment Authority. Mr. Ben Yezza was chair of the Libyan Investment Authority. The Al-Thini government then appointed Mr. Buhadi as chairman of the LIA to replace him after concluding that Mr. Ben Yezza was subject to the political isolation law, which prevented those connected with the Gaddafi regime from holding certain offices. Well, Mr. Ben Yezza, now succeeded by Mr. Braish, he contends that he is the chair of the Libyan Investment Authority, relying on a disputed Libyan court decision to the effect that the political isolation law doesn't apply to him and relies on his purported reinstatement by the National Salvation Government. So we see there's an issue between the two factions as to who is entitled to control this litigation and who is entitled to act for the Libyan Investment Authority. There was previously a litigation committee consisting of representatives from both factions running the litigation, but they couldn't agree. This proved unworkable, and at the end of April, the solicitors, the London solicitors, who were on the record on both of these huge actions, came off the record as we all know solicitors warrant their authority, and the potential cost liability, if you happen to be in breach of your warranty of authority on this sort of dispute, was huge. So they came off the record, so there were then no solicitors on the record prepared to warrant their authority in in circumstances where it wasn't clear who was entitled to represent the LIA. 6 weeks of negotiations between the two factions produced no resolution. So we came up with the idea of having a court-appointed receiver to run the litigation. It had to be court-appointed because if it was party-appointed, one could see all the problems of lack of agreement and parties falling out and one refusing to cooperate would resurface. Now, you can see on an issue like that all sorts of problems in having a receiver run big litigation. How would the receiver deal with the different factions? How would the receiver be assured of having sufficient funds, and particularly funds that weren't covered by sanctions orders? Who would sign statements of truth and on what basis? Would the receiver have the ability to obtain proper disclosure from those who were in possession of the documents? In other words, could he be assured of giving proper disclosure? So his powers, the powers which the court would give him, could not, in principle, be limited to powers to run the litigation. There had to be a whole range of ancillary powers too. In the end, I think we had originally thought that the solicitors might be able to act as receivers. In the end, partners of a major firm of accountants were appointed, and they were going to run the litigation in what they saw as the interests of the Libyan Investment Authority, and the terms of the order required them to re-instruct the solicitors previously instructed in the litigation. So there were hearings in the commercial court before Mr. Justice Flo on the application for the appointment of a receiver. Pretty well everybody was there. I'm sorry if you missed it. Apart from the two rival factions, the receiver was represented and had views as to what power were necessary, and all the defendants were represented separately. The judge said they were entitled to be heard on the issue because they said they were potentially prejudiced by the making of an order. They initially took the position, purely disinterested of course, that the receivership wouldn't work at all, and it was better to wait and do nothing and see if the United Nations Peace Initiative in Libya bore fruit. Then they were required by Mr. Justice Flo to set out in writing their objections to the order, and they came up with 28 of them. In the end, the judge did make an order. He took the view it should be an interim measure, that he would wait to see if the United Nations peace talks bore fruit, but said if not, he would require proceedings to be commenced between the two factions, and therefore the question of who had the authority was going to be, and is going to be, decided by the English court. He required the representatives of both factions to agree to submit to the jurisdiction for the purpose of a determination of the question as to who had authority. The receivership order went through, I think, over 100 drafts. Pretty well everybody had something to say about it. There were changes. The two factions obviously had a lot to say about it. The receiver had things to say about it. The defendants had all sorts of things to say about it. Today, the United Nations peace proceedings have not resulted in a settlement, and the proceedings between the two factions on the question of authority have now been commenced. And it's anticipated that there will be an expedited trial in the commercial court next year. So, just pausing there and to look at this, as it's a somewhat unusual order, and it's a somewhat unusual way of dealing with a perhaps rather unusual problem. The idea of a receiver making decisions in the best interests of the Libyan Investment Authority is not in itself a particularly unusual concept. For example, liquidators often litigate in the Chancery Division, acting in the best interests of the company in liquidation and its creditors. In a case that you'll see on the slide, in the Abliazov litigation, Mr. Justice Tier made an order appointing a receiver to conduct litigation for one of the parties where there was a power struggle within that particular company and gave rise to similar issues. Now, if one thinks that there have recently been civil wars in Nigeria, Central African Republic, Burundi, Mali, Somalia, Sudan, and Congo, leaving aside problems such as Syria, you can see that it might not be a unique problem. The advantage of a court-appointed receiver or manager is that the appointment and the appointee is independent of the parties completely, and although the receiver was required to consult each of the two factions, that was it, and the receiver had to make the decisions himself and report to the court. So long as the receiver has money, sufficient powers to enable him to comply with court orders, such as for disclosure, this, although perhaps a somewhat innovative solution, protects the litigation and prevents either party from asserting its own control. Thank you.
Thank you, Charles. I'm going to reflect on some lessons to be learned from a case I was involved in called Renaissance Capital and African Minerals. Before I do, I've had a message from the people who are in charge of the number 5 Chambers planning session. They've asked me to pass on their thanks for those who attended their lunch, their invaluable input into their planning. As a result of your strategic thinking, they're opening a branch in Nairobi next year, so well done. Now, you might expect a case in which one of the parties is actually called African Minerals, and where the underlying facts concern the development of the largest iron ore mine in the whole of West Africa, to be a quintessentially African case. But I'm afraid I have to come clean and admit that although Sierra Leone provided the exotic backdrop to the case, the crucial contract which we were arguing about had English law and English jurisdiction as an express choice. So when you boil it down, this was actually a classic London Commercial Court dispute. And every case you ever do teaches you something. I just want to highlight 3 points that were raised by the case, which I think are worth pondering. Two of them are fairly commercial. One of them is a litigation tactics point. The first commercial point to bear in mind is to realize, and this case really brought this home to me, just how significant Chinese investment in Africa has become. So this mine, which is a place called Tonkalili, which is it was in the middle of the Sierra Leonean jungle. It was absolutely top class, still is, iron ore asset, genuinely a world-class mine. But in order to realize the potential that it had, it required an absolutely huge amount of cash. Not only have you got to dig a mine, but you've got to they had to build a railway, hundreds of kilometers of railway, all the way from the jungle to the coast. And they had to build a deep water port capable of taking ships which could transport iron ore in bulk. Otherwise, as one of the witnesses dryly remarked, if you don't bother with the railway, you've got a very, very expensive hole in the ground and nothing else. So the issue for African Minerals was fundraising. They were constantly having to raise money to complete the next phase of the project so that they could convince the next set of investors to raise the next lot of money. And the man behind African Minerals, who's a well-known city figure called Frank Timmis, who's a brilliant entrepreneur, and he was able to raise what in the context of this project, I'm afraid, was petty cash of a few $100 million here and there. And he got that from financial investors, people who aren't interested in iron ore, they're just interested in making money. What he really wanted was a strategic investor, somebody who wasn't just looking for a quick buck, but actually wanted to own a mine, an iron ore mine, or a part of it. And that was where the claimant in the case, Renaissance Capital, came in. They're a Russian bank. And the idea was that they sold themselves to African Minerals on the basis they had good contacts in Russia and in the Middle East. They'd be able to find somebody who was interested in buying a large slice of equity for big money. And basically they failed. They got a few Russian companies who were a bit interested, but it was all flirtation. It never got anywhere. And it was only once African Minerals appointed a new managing director, who was a man with contacts in the Far East, that things really started to roll. And that was because, you could see it from all the underlying documents, the Chinese entities were serious. China needs steel. And of course, we all know that the Chinese economy fluctuates, so the exact demand varies. But the basic proposition remains, China needs steel. And for steel, you need iron ore, and for ore, you need mines. And state-owned entities in China don't muck about. They have, once they've decided to do something, they have got a very, very large checkbook. For example, in his visit to the African Union in 2014, the Chinese premier announced that China expects to raise direct investment, this is just their direct investment in Africa, by 2020 to $100 billion. They have huge funds to invest. And this mine was a classic example. Once they looked at it, they surveyed it, they checked out the quality of the ore. They were prepared to pay $1.25 billion for a 25% share. And they didn't really care about the short-term fluctuations, share price up and down, iron ore price up and down. They take a 30, 40-year view. They want to supply a top-quality supply of raw materials, and they were going to pay for it. So the first point to draw from the case is actually that Africa and China are now inextricably linked. I strongly suspect that that is going to result in an ever-increasing flow of this type of litigation into London. Because although this may strike you as a somewhat cynical view, I have found that very few commercial entities who are contracting with a Chinese state-owned entity are very keen on signing up to Chinese law and Chinese jurisdiction. So they're looking for a neutral venue, and once you start looking for a neutral venue, London always emerges high up in the list. Though I have to say against interest that quite a few of the contracts in this case were, the compromise was Hong Kong law and jurisdiction, something which will please Charles enormously, because his youthful appearance belies the fact that he is actually the youngest member, newly admitted member of the Hong Kong bar this year. Now, the second commercial point, which is a sort of crossover into legal practice, is pure corporate finance, really. Because the banks who act on these huge transactions don't do it for an hourly rate, so if the transaction doesn't go ahead, they get nothing. They do it for a cut of the money that's changing hands, for commission. And so the commission terms in a contract whereby you're engaging a bank are unbelievably important. And I know that that sounds incredibly basic, and it is incredibly basic. But if you are an in-house lawyer at a company engaging a bank, or you're an external lawyer who's been sent a contract with a bank to review, you've got to focus on the fee arrangement. It's absolutely critical, and nothing else really matters. And banks are brilliant at hiding the fee arrangement. You start reading, there's pages of guff about what they're going to do and the skills they're going to bring to bear and all their expectations and blah-de-blah-de-blah. None of it matters. It's all flannel. The critical point is what triggers their commission. That's really where you need to go to straight away. And of course, there are all sorts of ways to slice a commission, as anybody who's ever sold a house and looked at an estate agent contracts knows. And the same points arise on these deals for billions as arise when you're selling your house. First question is, do they only get a fee if the investor or the buyer is somebody that they actually introduced? And if that's not the case, and the bank is always very keen to try to avoid that, are you, as your client, happy with that? Do you want to be paying a large fee to a bank which hasn't actually come up with the goods, hasn't introduced the buyer? If they do have to introduce, is there a time limit? Because what a bank wants, if it's got to introduce, is to structure the contract so that if they introduce somebody, then if you do any deal with them in the next 10, 20 years, they don't care, they get a cut. You've got to avoid that trap and try and get it to no greater than a year, for example. And then, as well as just the introduction issue, the question arises, which became the central question in African Minerals, what point does the deal itself actually have to get to before that fee entitlement arises? So on an extreme terms, and estate agents used to do this in this country as recently as 20, 30 years ago, they said, well, look, if we've introduced a buyer who is ready, willing, and able to buy your house, that's it. We've done our job and we get our cut. It doesn't matter if they didn't actually buy your house, if you changed your mind about the deal or you found something unsatisfactory, we get our commission anyway. that still exists. Some estate agents still trying to get that into their contracts, so do some banks. Other sets of terms say, well, the commission is earned when you exchange unconditional contracts. Another one is the commission is only earned on completion, when the money passes hands. And obviously, this is all out there for commercial negotiation. The critical thing is to be aware of it as a risk area, because in African minerals, nobody really looked at it. A very opaque clause got through, which said that the bank was entitled to its fee when any deal consummated, that was the word, and you're off to the races in terms of what the hell does that mean, or at what point does a deal consummate. The third and final point is a litigation issue, which is a really general application, and it's the use of witness statements. Because although at the heart of this case it was a relatively simple construction dispute, which in the Court of Appeal we dealt with in a day and a half, the actual trial, the first instance trial, lasted well over a month. I think it was 5 or 6 weeks, because it got bogged down in some very lengthy evidence about estoppels by convention. Now, just in case you haven't bumped into one recently, by way of reminder, an estoppel by convention is where you say, yes, the contract means X, but if it doesn't mean X, everybody actually thought it meant X, and they behaved as if it meant X, and based themselves in that way, and it would be unfair now for it to be held that it doesn't mean X. So Renaissance put up 2 bankers to support this case, giving evidence, claiming to remember all sorts of occasions, all, funnily enough, undocumented, in which African Minerals employees, right up to the chairman, actually particularly the chairman, had said things which supported their case on construction, on the phone, over lunch, at dinner, on a plane, in a car coming from the plane, and during late-night discussions over some rather good bottles of wine. It was a very elaborate story. And between them, they had made witness statements which totaled over 300 pages. So I had to cross-examine them for a long time. And actually, it turned out to be relatively straightforward, because the judge didn't believe a word of their story. But it did lead to him saying this right at the back of his judgment. He said, this is his final paragraph, "The trend to produce over-lengthy and argumentative witness statements must stop. It is wasteful of costs and the court's valuable time. The profession should not be surprised if in the near future the Commercial Court Guide is amended so as to limit the length of witness statements, requiring the leave of the court to exceed the limit, and require the parties to confirm and report to the court post-CMC that the witness statement rules have been complied with." I mean, he was fed up. Mr. Justice Field is at the end of his career, so he's kind of telling it like it is. And he's just fed up with long witness statements. And the real point here, I think, for litigators in the room, is that we have to reevaluate the function of a witness statement. Because suddenly I seem to have found myself so old that I know lots of judges personally. And so you can talk to them in a way that is open to you on a personal connection. And I can tell you from a very unscientific survey that judges are not keen on playing through a 150-page witness statement. It is boring. Just think about it. A judge has got a lot of reading to do before a trial starts. Skeletons, experts, key documents, some law. It's got a lot to think about. And they never get given enough time. And we do not always serve our clients well by trying to be too thorough. If we help witnesses to assemble statements covering every aspect of the case in exhaustive detail, but are so long, and let's face it, dull, that they're never actually going to be read, then they are not going to make the impact that they would if we could boil them down. So those are my 3 takeaways from African Minerals. As I said, not, I'm afraid, particularly African, but a case worth keeping in mind.
Good afternoon. The promise of this session is that comment and insight will be provided into recent cases. And whilst I promise no great insight, the recent commercial court decision on which I want to at least briefly comment is the decision of Mrs. Justice Gloucester in EVP and Malibu, the citation for which should hopefully now be on the screen. We visited briefly since lunch both Libya and Sierra Leone, and what I'd like to do is draw everyone's attention at least briefly eastwards towards Nigeria, and more specifically to the very most southerly tip of Nigeria, which juts out into the Gulf of Guinea. If you were then, as part of this imaginative expedition, to travel due south for a couple of 100 kilometres, you'd reach an area of Nigerian territorial waters known in the oil industry as Oil Prospecting License, or OPL 245. OPL 245 is, at least potentially, one of Nigeria's most valuable prospective oil blocks. And for reasons that are probably not unconnected, it's also been one of the most litigated, including before the London Commercial Court. Its potted legal history perhaps provides a study in microcosm of some of the legal difficulties that can arise in relation to assets of this type. For present purposes, the story of the block begins during the regime of the Nigerian military dictator General Abacha, who was the president of Nigeria between 1995 and 1998, and there are no prizes for guessing, is the man pictured at the far left of the screen. In around April 1998, when Abacha was still in power, the federal government of Nigeria awarded a 100% interest in a license for OPL 245 to a Nigerian company called Malibu Oil and Gas Limited, which was the defendant to the commercial court proceedings. At the time of the award, the Minister for Petroleum of Nigeria was a man widely known as Chief Etete, who is the other individual pictured. The actual award to Malibu of the license relating to OPL 245 was recorded in two formal letters from Chief Etete's office at the Ministry of Petroleum Resources. And so far, you may be thinking, so good. The slight difficulty was, according to the eventual findings of Mrs. Justice Gloucester in the Commercial Court, Chief Etete, apart from being the Minister of Petroleum at the relevant time, also had a substantial beneficial interest in Malibu, which was hidden behind the facade of what appeared to be two or three fictitious and possibly non-existent individuals. The true history of the commercial rights to this block have been contested. However, according to what Mrs. Justice Gloucester described in her judgment as the most realistic analysis of what had actually occurred, the license to the valuable OPL 245 had been awarded first to Malibu, in which both Chief Etete and the family, in fact, of General Abacha had a beneficial interest. However, following General Abacha's death in 1998, Chief Etete had then taken advantage of the situation and had effectively cut out Abacha's interests. In 1999, following General Abacha's death, there were then elections in Nigeria in which President Obasanjo was elected to power, who then almost immediately entered into a process of revoking oil and gas licenses that had been arguably corruptly awarded during the previous regime. For whatever reason, Malibu and Chief Etete at least initially survived the cut. And so by the time you get to the turn of the millennium, Chief Etete, describing himself in commercial dealings as a consultant to Malibu, had begun the process of trying to develop and realize some value in the asset. At first, Malibu began to try and develop an interest and some commercial value in the license by entering into a farming agreement with a subsidiary of Shell. However, a degree of legal chaos then followed when the relatively new government of President Obasanjo revoked the license that had initially been granted to Malibu. And so, perhaps somewhat predictably, this led to legal proceedings, a quagmire of legal proceedings, in which both the Nigerian government, Malibu, and various companies associated with Shell were involved. And these included, amongst other things, an ICC arbitration, federal court proceedings in Nigeria, as well as a series of investigations by the Nigerian House of Representatives. Eventually, slightly bypassing Shell, Malibu managed to reach a settlement with the government of Nigeria, and so was re-awarded the license via a settlement agreement in 2006. And this will become relevant later, but shortly afterwards, Chief Etete was convicted in France of various money laundering offences and had to pay an €8 million fine. So in short, by this stage, taking account of the previous revocations of the licence, the long-running disputes with Shell, and also the criminal conviction of Chief Etete, OPL 245 had, for understandable reasons, become something of a toxic asset. And there, for the following 3 years, therefore, Chief Atete tried with no obvious success to realise some value and effectively find a purchaser for the asset. Eventually, in around 2011, Malibu did agree to surrender its interests in OPL 245 to the Nigerian government and received around $1 billion. And as part of the same suite of transactions, the Nigerian government reissued the license to companies associated with ENI and Shell, who in return paid an identical amount to the government. The reason this all ended up relatively recently before the London Commercial Court is because the claimant company in the proceedings, Energy Venture Partners, or EVP, had, according to its case in the Commercial Court, provided brokerage services to Malibu and had effectively managed to succeed where Malibu had failed in finding a purchaser for the asset. EVP was itself a BVI company owned by an English-Nigerian investment banker called Mr. Obi. Mr. Obi's evidence in the proceedings was that it was only as a result of his assistance over the course of roughly 2 years, and in particular his exploitation of his own relationship with ENI, that Malibu had in fact been able to sell the asset. And therefore the claim that was brought before the London Commercial Court was a $200 million claim by EVP for Malibu for what were in effect unpaid brokerage fees. The issues that were faced in bringing the claim in the Commercial Court are perhaps not completely untypical of the type of issues that might arise in relation to disputes involving West African assets before an English court. Although it might be a problem in some cases, jurisdiction wasn't a problem here, as there had been an agreement between EVP and Malibu containing a jurisdiction clause. The first and probably the greatest challenge was that faced the legal team to begin with was therefore finding a way to effectively and practically secure its claim. For obvious reasons, obtaining an English judgment against a Nigerian company owned by what appear to be fictitious individuals is one thing, but actually enforcing it subsequently might be another. However, in a stroke of luck for Mr. Obi at least, the payments that were made by the ENI and the Shell companies in order to acquire the OPL 245 were paid into an account of the federal government of Nigeria, which was held by JP Morgan in London. So as a result of this, on the 3rd of July 2011, quite soon after the money had been transferred, EVP was able to obtain a worldwide freezing order, freezing Malibu's assets to the tune of $215 million. And as a result of various relatively dull procedural hearings that followed, the upshot was that it was agreed that $215 million would be paid into court pending resolution of the proceedings. So with funds to the tune of roughly $215 million happily secured in court, the proceedings began to advance in the normal way. EVP's principal claim was that as a result of an oral variation of a written agreement between the parties, which didn't itself specify any fee, it had been effectively agreed that EVP would be paid a success fee of $200 million in the result of the successful sale of the asset. And so the $250 million that was paid into court was intended both to secure the $200 million claim and then to include a little bit of fat for interest and costs, etc. EVP's alternative claim were effectively two quantum meruit claims, a contractual quantum meruit and alternatively a claim in unjust enrichment for the value of its services. Now the second practical challenge that was faced regarded disclosure. If anyone's ever been slightly worried as to matters such as whether their firm's document retention policies are adequate, then I suggest you take some comfort from the position of Malibu. Despite there being frequent interaction between the parties over the course of around 17 months in relation to a dispute worth, in relation to a transaction, worth at least $1 billion, Malibu's total disclosure included 3 emails, 1 handwritten note, and an overall total of 176 hard copy documents, which Justice Gloucester pointed out mostly related to historical issues rather than anything obviously relevant to the case. Indeed, the high watermark, this obviously gave rise to some potential lines of questioning in cross-examination. And the particular high watermark, I think, came when, in the middle of cross-examination, Chief Atete accepted that it hadn't occurred to him to, in fact, take the relatively dynamic step of searching for relevant documents on his computer. The third challenge, so that was disclosure. The third challenge was witness evidence. In total, Malibu tendered 2 witnesses, Chief Atete and an individual called Mr. Gabinigi, whose role Mrs. Justice Gloucester simply described as being that of a yes man. The challenge, that wasn't the challenge. The challenge was that shortly before trial, the news broke that Chief Atete was to be refused entry into the United Kingdom under what was then Section 320 of the immigration rules, as a result of a non-disclosure relating to his French criminal money laundering conviction. Now, what was proposed by Malibu is that instead Chief Atete should give evidence by video link, which in some cases might be an acceptable solution, but in this case was viewed, at least by the EVP legal team, as unsatisfactory, given that the principal or central issue in the proceedings was going to be Chief Atete's credibility. Since Chief Atete was able to travel to Paris, although not onwards to London, we successfully applied to the commercial court for the court to, for a week of the proceedings, travel to Paris and take Chief Atete's evidence in person using a rarely used procedure under the taking of evidence regulation. There's still, in fact, very little precedent for this procedure, and it requires a relatively specific set of facts in order to work. But in a case where a witness's credibility is key, and perhaps video link evidence is not sufficient, then it can be an important option to consider. The procedure does, however, give rise to a number of practical considerations. Firstly, permission is needed from the English court, which itself is relatively straightforward. It simply involves making an application in the proceedings. Secondly, permission is required from the relevant overseas court, which is slightly less straightforward because the regulation includes various slightly impenetrable forms that have to be submitted, completed, and sent off to the relevant overseas court, which then has to grant permission. As for the taking of evidence under the procedure itself, the regulation provides that the local court may attend the hearing in order to ensure compliance with the regulation. But although in some cases that might sound relatively off-putting, I don't think it probably happens very often in practice, and in this case it certainly didn't. Instead, what happened was that the parties simply booked a hearing room at the ICC Centre in Paris, and for all practical purposes, the hearing proceeded for a week as though the court had been sitting in London. Of course, the final practical issue that had to be faced in that regard was not just making travel arrangements for the parties, but making various arrangements for the court. And it's hopefully not impugning the legal system too far to suggest that a slightly gentle hint at an appropriate point at a rather upmarket hotel for the judge and for the various court staff might not do the application any harm. And the other practical point, of course, is separate hotels, because that avoids the risk of slightly unfortunate meetings at the breakfast buffet. At trial itself, we did get to trial. The key week in Paris went very well. And I'll suffice it to say simply that relatively colourful conclusions were reached by Mrs. Justice Gloucester regarding Chief Atete's personal credibility, or lack of credibility. EVP's claim that there had been an orally agreed fee of 200 million did not succeed, but EVP was successful on the contractual quantum merit ground, meaning it was unnecessary for the court to go on and assess the fee that would have been payable on a restitutionary basis. So in this regard, what the court effectively did is to look very closely at the parties' actual negotiations, and by taking into account the level of fee the parties were themselves contemplating, albeit that they hadn't finally agreed upon a fee, EVP was granted judgment for $110 million on the basis that this was a reasonable fee for the services that it had in fact provided. In a number of respects, the case, despite its obvious practical difficulties, was therefore a success. Although it's fair to say that the future of the OPL 245 licence and asset itself still remains uncertain. In particular, for example, in a relatively high-profile investigation in Italy involving the senior management of ENI, prosecutors have been investigating ENI's acquisition of the asset. And in a further twist, which perhaps serves as a reminder that the commercial court can on occasion only be a staging post in an international dispute, EVP subsequently had various assets frozen in connection with the Italian investigations. Whereas in another slightly bizarre twist, Chief Atete received a pardon from the French government in connection with his various charges. So in short, whilst the legal whirlwind surrounding OPL 245 may now probably have blown its way completely through London, the storm itself continues to blow.
Thank you, Ed. We've just got a couple of minutes if there are any questions about litigating African disputes in London. The next topic is arbitrating disputes, including enforcement of awards from Africa. So we could also pick up some questions at the end of that because they're both dispute related. I can't see anyone burning to ask a question. Oh, no, we do have one. There should be a mic coming your way. If you could just state your name before your question.
Tess Ford from the law firm Adelshaw Goddard. I was just wondering, in the case that you just mentioned about OPL 245, were the issues of illegality ever brought into question?
Not directly. There was what was called a fraud defence by Chief. That was a defence by Chief Atete, but it was in fact a defence that never needed to be decided. I mean, there was an issue in the background of the case, which is that I think, to be completely honest, the legal representatives had a concern, given the background to the asset and the fact that there was money in court, that a little bit too much of emphasis in the proceedings as to how the money came into Malibu's hands would not strategically have been helpful. And so, in a sense, we had to steer quite a careful path between establishing what we needed to establish in cross-examination, but not going so far as for the court to perhaps think, actually, should I be doing anything with this money? And in fact, there have been, we learned afterwards that the Metropolitan Police was investigating the money. We didn't know that at the time. And it decided not to take any steps because effectively there had been a relatively recent decision by the Nigerian government at that time that the award to Malibu was okay. And subsequently, it's completely possible that would have taken a different turn and somebody would have turned up in court one day and said, actually, the police want the money and everyone else has got to go away.
Oh, just one further question at the back.
Lives, I'm a solicitor at Anthony Seddons. Is it still possible in the future for the money in court to end up as a pursuit of crime under the POCA and for repatriation into Nigeria under the ONCAC?
Well, the Metropolitan Police, we found out afterwards, were in fact it was the POCA unit that was, the proceeds of crime unit that was investigating. And they took the decision, which was all, we had no visibility of this, but they took the decision during the proceedings they weren't going to intervene. And I think actually it's all public. A judicial review of that decision was made by an NGO, I think called Global Witness. And those judicial review proceedings of that decision, the proceedings were unsuccessful. And then that subsequently was published by Global Witness. And in fact, I read through it all the other day. What happened subsequently is that a lot of the money went to Mr. Obi, and then that money was frozen, but that was pursuant to the Italian investigation by E&I. So in terms of where the money is now and where it may end up, I think it's more to do with the investigations in Italy, to do with E&I, and what happens there.